I had exactly $11,842.16 in my checking account the morning I opened the package that proved my husband had been lying to me for 12 years. I was sitting at my kitchen table in a rented duplex outside Lexington, wearing the same gray cardigan I'd slept in for 3 nights after the funeral, still moving like someone who expected him to walk in and ask why the coffee had gone cold. Inside the padded envelope was a brass key, a property tax notice for a farm in Mercer County, and a flash drive labeled in neat black ink. If anything happens to me, give this to Ella. My husband had forbidden me from setting foot on that farm from the day we married. Now he was dead, my name was on the tax notice, and the county clerk's voicemail waiting on my phone ended with a sentence I still hear in my sleep. If you miss this filing deadline, you lose everything. Let me take you back. My husband, Grant Holloway, died on a Thursday in February when his truck drifted off a 2-lane road and struck a guardrail near Harrodsburg. That was the official version. I repeated it to neighbors, to my sister, to the woman at the funeral home who kept asking whether we wanted the mahogany casket or the walnut. Official versions are useful in the first 72 hours after a death. They let you keep breathing. Grant and I had been married 11 years. I taught 11th grade English at a public high school. He ran a regional agricultural supply business his father had started, and his older brother, Dean, liked to describe as the real spine of this family. Grant was quieter than Dean, steadier too. He ironed his own shirts. He paid every bill 3 days early. He never raised his voice. That kind of man can hide entire rooms inside himself. There had always been one locked room in our marriage, the farm. It came up our first summer together, when we were still pretending privacy was the same thing as mystery. I had asked whether we could drive out one Sunday after church, maybe picnic there, maybe see the pond he mentioned whenever he got nostalgic. He didn't answer right away. He set down his fork, folded his napkin, and said, very calmly, no. You are never to go there, Ella. I laughed because it sounded absurd. Never. Never. The word didn't get louder. It just got colder. I asked why, and he gave me the explanation he always used after that. Old structures, liability, broken fencing, insurance issues. Then he added, please don't make me repeat myself. That was Grant's way when he wanted control without appearing controlling. He didn't insult. He didn't threaten. He made refusal sound administrative. The second incident came 4 years later, after my mother's stroke, when I was driving back and forth to Frankfurt every weekend and barely sleeping. I remember standing in our hallway with my coat still on, asking him if he could cover one Saturday at the hospital because I had papers to grade and couldn't keep doing everything. Dean had stopped by earlier that day and told me, in the slow, pitying tone he reserved for women he considered decorative, you're good with casseroles, Ella. Let the men handle land and money. Grant heard him say it. He said nothing. Then, when I brought up the farm again that night, because I had started to suspect he was spending more time there than he admitted, he looked at me with that same smooth expression and said, you are exhausted. You're imagining problems because it gives you something to organize. It was the cleanest kind of cruelty. It left no bruise and made me question my own memory. So I stopped asking. That became our marriage in miniature. He drew a line. I learned to step around it. 3 days after the funeral, I met our family attorney, Martin Keene, in an office that smelled faintly of lemon polish and old paper. He handed me the envelope, the key, and the flash drive. Then he pushed a manila folder across his desk. Grant left instructions, he said. For the farm, the deed, and a filing with the county court. There is a transfer challenge already pending from your brother-in-law. I stared at him. Dean. Martin nodded. He claims the farm was held in trust for the family business and that you have no surviving ownership interest. If you miss the hearing on Monday, the court may enter a default order affecting title. I actually dropped my pen. It rolled under his credenza. That small clatter sounded indecent in the room. Why would Dean do that 3 days after the funeral? Martin took off his glasses. Because timing is often part of the strategy. That night I plugged in the flash drive. There were only 3 items on it, a scanned deed, a video file, and a PDF folder titled Read Second. I opened the video first. Grant appeared on screen sitting in what looked like an office I'd never seen, wearing his brown work jacket and looking more tired than I had ever let myself notice. He said my name once and stopped to clear his throat. "If you're watching this," he said, "Dee moved faster than I hoped. Do not let him scare you into signing anything. The farm is not part of Holloway AG Supply. It was transferred to an LLC 2 years ago, and you are the sole beneficiary under the operating agreement. Martin can explain it. I should have explained it. I know that." I paused the video because my hands had started trembling. He went on to say there were records of the farm. He said I would be angry and that I had every right to be. Then he said something that made me sit back hard in the chair. The women there need protection. If Dean gets control, he'll remove them within a day. The women there. I watched the rest in silence. Grant didn't cry. Neither did I. We had never been that kind of couple. But when the video ended, I put the phone face down beside me and sat in the dark kitchen until dawn. On Saturday, I drove to Mercer County with the brass key in my coat pocket and a legal pad on the passenger seat. It rained the entire way, the fine needling kind that makes even familiar roads look provisional. The farm sat behind a long line of cedar trees, farther back than I expected. White house, red barn, fresh gravel on the drive, security cameras under the eaves. Nothing about it looked abandoned or unsafe. It looked maintained, intentional. I unlocked the front door and stepped into a warm hallway that smelled faintly of soup, laundry detergent, and crayons. I stopped walking. There were rain boots lined against the wall, a pink backpack with a cartoon fox on it, a stroller folded near the stairs. On the entry table sat a bowl filled with hair ties and mittens in different sizes. Family photos covered the far wall, but none of the faces were mine, and none were Grant's. Women smiling carefully, as if they were still practicing safety. Children in school uniforms. A toddler in a pumpkin costume. Then I heard a child laugh upstairs. I should tell you I wasn't brave in that moment. I nearly left. My first instinct was to back out, get in the car, and return to the life where confusion was at least familiar. But then a little girl's voice said, "Is he gone?" and something in me changed shape. A woman appeared at the top of the stairs holding the hand of a child who couldn't have been older than 5. Another woman stepped out from a back room carrying a laundry basket. Both stared at me with the stillness of people who had learned to assess danger before language. "I'm Ella Holloway," I said. "My husband owned this property. He died last week." The woman with the child went pale. The other set the basket down slowly and asked, "Dean told you where this place is?" "No," her shoulders lowered by half an inch. "Then come inside and close the door." Her name was Marisol Vega. She had once worked in hospital billing in Louisville and now ran the house with a competence I recognized immediately. The child belonged to Tasha, a 23-year-old mother hiding from an ex with 2 pending assault charges. There were 4 women on the property that week, plus 2 children. One had come through a church referral in Danville. One had been sent quietly by a social worker who had run out of official beds. Grant hadn't built a farm. He had built a shelter in plain sight and hidden it behind my obedience. I wanted to be furious in a clean, simple way. I wanted him to become one thing, noble or deceitful, generous or cruel. But real people are greedy with contradiction. He had lied to me for years. He had also been paying for trauma counseling, food, diapers, motel transitions, bus tickets, and legal retainers through an LLC called Blue Heron Land Holdings. Marisol handed me a ring binder from a locked cabinet in Grant's office. He said if something happened to him, you'd need this. Inside were resident protocols, emergency contacts, vendor invoices, and copies of lease addenda written by someone who understood exactly how exposed these women could be. There were notarized statements, intake summaries, and agreements with names redacted. A retired family court judge in Boyle County had helped draft some of the documents. A therapist in Lexington donated 2 Saturdays a month. A church in Nicholasville supplied food cards without asking questions. Social twist, I suppose, though at the time it felt less like a twist than a quiet map of decency. At the back of the binder was the PDF Grant had told me to read second. I opened it on the office computer. It was a forensic audit prepared by an outside accountant. Payments had been moving out of Holloway AG Supply into a vendor account Dean controlled, then into an equipment shell, then back into parcels Dean was trying to consolidate under the family business. Buried in the audit notes was the reason the farm mattered. Its access road connected to acreage Dean needed for a warehouse development deal. If he secured title to my property, a bank in Nashville would release the final financing tranche. The second folder changed everything. This was not just about secrecy. It was about leverage. I called Martin from Grant's desk. He listened for 6 full minutes without interrupting me. Then he said, "I'm sending an associate and a process server. Do not sign anything. Do not let Dean on the property." And Ella, "Yes, this isn't revenge. This is justice." By Sunday afternoon, we had a plan. Martin's associate, Priya Banerjee, arrived with copies of the LLC operating agreement, the transfer deed, and metadata reports confirming the documents had been executed and scanned months before Grant's death. That mattered because Dean's lawyer had already suggested the deed was fabricated after the accident. Priya explained each piece in plain English, the way good lawyers do when they want frightened people to stay useful. Metadata shows when the files were created, modified, and stored, she said. The notarized signature on the deed matches the clerk's book entry. The LLC membership ledger names you as successor manager upon Grant's death. There's also a fraud carve-out in the family business trust. If Dean used company funds to pursue personal title claims, he loses indemnity protection. I wrote all of that down, underlining words twice because it helped me breathe. Then Dean arrived anyway. He came just before dark in his black SUV, wearing a navy overcoat and the expression he used at funerals and Rotary lunches, the one that translated as patient concern to anyone who didn't know him. He stood in my doorway and glanced past me into the hall, taking in the stroller, the shoes, the drawings. "So it's true," he said softly. "Grant really did fill the place with strays." Behind me, Marisol went still. I said, "You can leave now." Dean smiled without warmth. "You're in over your head. These women have no formal tenancy, no licensing, no insurance protections. A sheriff can clear this property before the week is out. Based on what claim? Based on the fact that it belongs to the company." Priya stepped into view with a file in her hands. "Actually, Mr. Holloway, you've been served." His face changed then, just briefly. Surprise first, then calculation. The papers were for Monday's hearing and a separate emergency motion to preserve records, freeze disputed transfers, and bar interference with occupants pending review. We also included the audit exhibits. Dean's mouth flattened. Grant always did have a weakness for damaged women. That was the moment I stopped mourning the possibility that he might still be family. "Get off my property," I said. He looked at me the way men look at women when the furniture starts speaking. "You don't know what your husband was." "No," I said, "but I know what you are." Then I waited. The hearing was held Monday afternoon in Mercer County District Court because the probate judge had agreed to hear the emergency title dispute on a limited basis before transfer. Not a glamorous room. Fluorescent lighting, dry heat, the smell of wet coats, and copier toner. Dean had expected a procedural rollover. Instead, the back row held a bank compliance officer from Nashville, the retired judge who had helped draft the resident agreements, one local reporter Priya had not invited but did not mind seeing, and 3 women from a domestic violence nonprofit who had come after Marisol made a careful call that morning. Dramatic irony is simply this. Dean still thought the farm was a real estate problem. His lawyer went first, arguing irregular ownership, incapacity, family intent, and unauthorized occupation by unrelated third parties. Smooth language. Empty center. Then Priya stood. She walked the court through the deed, the LLC, the clerk's ledger, the operating agreement, and the audit trail. She explained why the metadata mattered. She submitted an affidavit from the notary. Then she introduced the shell payments and the warehouse financing condition tying Dean's title push to a personal commercial deal not disclosed to the company board. The judge interrupted twice to ask direct questions Dean could not answer cleanly. Then came the smaller reveal turning into the bigger one. Priya said, "Your Honor, opposing counsel has framed the current residents as trespassers." We submit they are lawful protected occupants under transitional lease instruments funded privately by the decedent, and that Mr. Dean Holloway's efforts to dispossess them coincide with a pattern of asset diversion documented in Exhibit 12. Dean leaned over and whispered furiously to his lawyer. Then came the nuclear part. Martin requested the court play a short authenticated excerpt from Grant's recorded statement, not for testamentary drama, but to establish intent and explain the successor structure. The judge allowed a limited clip. Grant's face appeared on the courtroom monitor. Calm, tired, clear. If Dean challenges title after my death, he said, it will not be because the farm belongs to the company. It will be because he cannot complete the warehouse parcel assembly without it, and because he knows I kept records of his diversions. The courtroom went silent. You can feel silence physically when it lands in a public room. It changes posture. Even Dean's lawyer stopped pretending to take notes. The judge recessed for 20 minutes and returned with temporary orders preserving title in my name pending final review, freezing disputed transfers connected to the shell accounts, prohibiting Dean from entering the property, and referring the audit package to the county attorney and the company's board counsel. It was not the end. Real endings rarely happen in one afternoon. But it was official consequence, and official consequence is what keeps fear from becoming policy. Outside the courthouse, Dean tried once to approach me. A deputy stepped between us before I needed to say anything. Within 2 months, the board suspended him. The bank pulled financing. The shell vendor was subpoenaed. A civil fraud action followed, then a negotiated settlement that stripped Dean of management control and forced repayment under supervision. He was never led away in handcuffs on the courthouse steps. Life is usually less theatrical than that. But public respect left him all at once, and for men like Dean, that is its own kind of weather. The harder part was the farm. I had a choice after the hearing. Sell the property, clear the residence, and tell myself I had honored Grant by saving what could be saved. Or stay and do the unglamorous work of turning his secret into something legal enough to survive him. I stayed. 1 year later, Blue Heron House had nonprofit status, licensed Transitional Housing Council, and enough grant support to keep 6 units open year-round. Marisol became operations director. Tasha finished her certification in medical billing and moved into her own apartment in Danville with her daughter. The little girl who asked whether he was gone learned to sleep through the night with a sound machine and a yellow lamp shaped like a moon. We built proper intake systems, resident rights documents, trauma-informed protocols, and a board that included exactly 0 Holloway men. As for me, I still teach part-time. I still misplace my reading glasses at least twice a week. I still stand sometimes in Grant's office at the farm and feel 2 things at once, gratitude and anger. He should have trusted me. He didn't. The good he did does not erase the lie. The lie does not erase the good. That's the part no one tells you about marriage or grief. Sometimes closure is not forgiveness. Sometimes it is accurate inventory. I kept one thing from our old house, the brass key from that first envelope. It sits in my desk drawer beside the final court order and the deed with my name on it. Not because I enjoy remembering what it cost to get here. Because boundaries matter more when you had to build them yourself. So that's my question for you. If someone you loved protected something important by keeping you in the dark, would you call that love, fear, or both? And if you've ever learned the hard way that self-worth begins where secrecy ends, subscribe and stay with me. Some doors are locked to keep danger out. Others are locked to keep the truth from being tested.